Good afternoon, everybody. Welcome back to House General and Housing. We have two hearings this afternoon. The first is on H-173, which is an act proposing to grant public higher education employees the right to strike. And second, at 2:30, we're going to hear again H-169, which is about prohibition of discrimination, in public accommodations and housing. And on H-173, our witness today is Sharon Reich Paulson, General Counsel of UVM. I think what I'm going to do, Sharon, is have the committee introduce itself to you. Can you start?
Emily Krasnow, Chittenden 9, South Burlington.
Sadia Lamont, Lemoore, Washington District.
Hi, I'm Elizabeth Burrows. I represent Windsor 1.
I'm Mary Howard. I represent Rutland City District 6.
I'm Debbie Dolgan. I represent St. Johnsbury, Concord, and Kirby.
Hi, I'm Tom Charlton. I represent Athens, Chester, Grafton, and Wyndham.
Joe Parsons, I represent Newbury Thompson.
Hi, Leonora Dodge from the town of Essex and the city of Essex Junction.
Welcome, I'm Mark Mahaly, and I'm representing Alice, Plainfield, and Marshfield. I'm the chair. And welcome, Sharon. Please give us your name and take it away.
Hi, I'm Sharon Reich Paulson. I'm General Counsel at the University of Vermont. And I want to, first of all, thank you for inviting me to come and talk to you about H-173. And also thank you for allowing me to be online. I'd rather be in the room, but I had another engagement obligation at the university that just ended a few minutes ago. So I had, I was not able to get to Montpelier in time, or I would be there with you in person. The various Vermont labor relations statutes, I think each provide an intentional power balance between labor and employer. Some give, as I know you know, a limited right to strike, and as the balance, give the employer the right unilaterally to impose a contract. Others, like SELRA, the statute at issue today, do not provide a right to strike and also do not provide the employer the ability to impose a contract. Instead, a statutory process is mandated that leads to the VLRB or an arbitrator imposing a final contract based on input from each party. The University of Vermont, Vermont State Colleges, and state employees are each governed by SELRA. I think it's important to look at the opening provision of SELRA, which contains a purpose statement. That's in section 901. And it describes the purpose of SELRA is basically to provide an orderly and peaceful procedure to protect the rights of employees and employer, and importantly, to protect the rights of the public in connection with labor disputes. Under SELRA, if the parties can't come to agreement on their own, then either party may declare impasse and trigger the statutory resolution process, which is mediation, followed by fact-finding, followed, if necessary, by the VLRB imposing a contract on the parties, taking one last best offer or the other last best offer of the other party or the fact-finding recommendation. What H-173 does is it takes away that balance of power and the public protection embedded in that balance. So it adds power on one side, the power to strike, with no balance on the scale for the other side. And importantly, also no guardrails on the strike power. So for example, there's no cooling off period before a strike is allowed, as in the Labor Relations for Teachers Act in K-12. There's also no limitation on strike power, as in labor relations, also as in the Labor Relations for Teachers Act, a limitation on strike power that allows a strike only so long as it does not endanger the health, safety, or welfare of the public. Those guardrails, that power balance, I think is important. Strikes, they're always challenging. but the potential impacts of a strike are materially different for UVM and the UVM community than they are in a K-12 context. Again, I don't want to minimize the impact on K-12, but there are some important differences. There are, for example, potential health and safety impacts. Our police are unionized, environmental health and safety personnel, animal care. In dorms, cleanliness of bathrooms, eating facilities, common areas are dependent on custodial care, building maintenance, electrical, water, things like that. You can't have students living in dorms that aren't cleaned, that aren't maintained, and that aren't having safety issues identified and addressed. There are academic impacts that are different than the K-12 context. Accreditation requirements mean that all time lost in a classroom must be made up. We can't simply easily extend a semester at the university. We have commencement, we have summer session. Importantly, students have jobs to get to, they have internships to get to, they have licensure exams to sit for that they may not be able to sit for if they haven't completed the required clinical hours or the other required academic coursework because a semester hasn't been completed yet. So these are just a few of the impacts that are unique in a university environment such as at UVM. I think actually the last negotiation with UVM Staff United, our newest staff union at UVM, is a kind of a good example of how the balance of power process set up in CELRA works. So this past year, between February and August of 2024, we had 18 bargaining meetings. This was a second contract with Staff United, so it was not yet a mature contract, and there was a lot to discuss. During those 18 meetings, both sides worked hard, and we came to agreement on 32 articles in those 18 meetings. We failed to come to agreement on 3 of them. Now, UVM felt we could continue to negotiate. Staff United did not.
Let me interrupt you for just a second. How many, you said between February and August, there were 18 meetings and you came to agreement on how many?
32 articles. We failed to come to agreement on 3 articles. Staff United declared proposed impasse. And so we went into impasse and started that process. Staff United offered the name of a single fact finder. UVM agreed immediately. The VLRB appointed that fact finder. Unfortunately, almost 2 weeks later, the fact finder withdrew because was not accepting any more work. So Staff United offered one more name. UVM offered 2 names the following week. We came to agreement on one of those names, and UVM agreed on the first of the 5 dates offered by the fact finder for a hearing. So the fact finder ultimately was appointed in October. We had a hearing in November. We had briefs due and the exhibits in January with a week extension requested by Staff United. The fact finder came to his very comprehensive decision in March, and in March, we came to agreement with each other on a contract that's now going through the ratification process with the union and will be presented to the Board of Trustees for final approval. We also came to agreement on making the economic changes to the articles retroactive for Staff United. So,
But Elizabeth has a question. Go ahead.
Can I ask a question now?
sure.
So does that mean that those employees that you're talking about were without a contract for 13 months?
No, it doesn't. What it means is that until a new contract is comes to agreement and is ratified, then the former contract remains in force and effect until that happens.
Thank you.
Okay. So I think what this shows, is that the power balance between labor and employer set forth in CELRA, it works. It protects labor, it protects UVM, the Vermont State Colleges, and the state, and it protects the public. The dispute resolution process under CELRA functions well because it really prevents the kind of deadlocks that require strikes or require unilateral management action to resolve. and instead creates a statutory process to resolve bargaining disputes that parties are unable to solve on their own, and it works. In that example I outlined, UVM students never experienced a work stoppage impacting their education. The fact finder facilitated a reasonable settlement between the parties, and the dispute procedures worked then as they were supposed to, protecting the rights of both parties and protecting the rights of the public served by the parties. In other words, primarily the students. And I'm happy to try to answer any questions if you have any.
Questions of the general counsel? Go ahead.
Thank you. A couple things. So when you say works, that to me is, I have a question, because clearly that there's still, if there wouldn't be discussion or a need for this if it was working for everyone. So when you talk about that it's working, one of the tools that the folks are asking for is one of the strongest tools that I believe creates a balance that is needed. And so I'm wondering if you can talk more, and maybe this is for another witness from UVM, but talk more about if you're having issues with retention or attracting people in addition to faculty, but staff that work at the college. And I'd also like to hear more about some of the timelines. This was also a question I had for the Labor Relations Board, but the timeline of how long it takes when someone has a complaint to the Labor Relations Board and how long that has taken in the past.
Okay, I'm happy to answer those. If I miss one of them, please let me know when I'm done. Let's just start with the timeline with the VLRB. To tell you right now, there are 4 matters pending at the VLRB, grievances or unfair labor practice claims. 3 of the 4 were filed in January. One of them was filed December 20th, but that's the Friday before the Saturday that starts the semester break at the University of Vermont, which all faculty and staff other than critical staff have off. So it's in effect filed also in January. So there are 4 pending right now that are underway, that are just from January. So that.
Yeah,
Yes.
Can you talk about the one that took 3 years?
I can look that up for you and get back to you, or have Wendy get back to you about that. Let me just make a note on that. So I'll make a note.
It's my understanding that there was one filed in 2021 and a decision didn't come till 2025.
I will look that up. In my experience with the VLRB has been quite responsible and responsive, and they're in the absence of some odd thing going on, it would never take that long. So I'll figure out what was going on there, and certainly someone will get back to you on that. In terms of recruitment and retention, there is not a problem at UVM in terms of recruitment and retention. I think we have good relations with the employees. Employees have good opportunities to help with students, to help with research, to engage in jobs that are a fulfilling part of a large team effort to promote education and research in the state of Vermont, and to provide economic development in the state of Vermont. So I don't think that that's a problem. I think that we are careful at University of Vermont to monitor and to watch the market rate for pay of different types of job classifications compared to market in the area and compared to the market for the particular kind of job that is impacted. And we are pretty much at median on that. In fact, the last for Staff United, the last offer made by the university prior to impasse would have put all of the UVM staff United employees at 98 point something percent of market. Let me just see if I can have my hands on that quickly. No, 99.7% of the comparable external market. And is there another question that I missed?
I'll ask one more. How would you feel about if this was aligned with the K through 12 policies for workers that you had mentioned earlier?
I think that would be a real challenge, because the situation for the population that is impacted by the work done at UVM is different than the population impacted at K-12. Again, I do not want to minimize the challenge of a strike in the K-12 arena, but a strike in the UVM arena would have far-reaching potential effects, including health and safety effects, potentially depending on which labor unit was striking and which members of that unit were striking. If faculty were striking and that impacted the ability of students to complete their degrees or to graduate on time or to complete the credits necessary for them to engage in their internship or clinical work over the summer or over the semester, that has a real impact and will delay the educational opportunities of those students. If it's police or environmental health and safety individuals, then we might have to close labs. We might have environmental health and safety impacts on the campus. Again, we have students, thousands of students living in dorms. Those dorms are serviced by custodial staff, by engineers, by electricians, by plumbers. We can't have students living in buildings that are not being serviced appropriately, because that provides a health and safety problem, and yet where are those students going to go? So the impacts are materially different in the UVM context than in K-12, again, without minimizing that an impact in K-12 and on parents and students is also a challenge, but it is a materially different kind of challenge in a research university context.
And I'll just close with, I just want to, remind the committee and, you'd mentioned, so I think there's a strike tool is not the first tool in the toolbox of discussions and negotiation. And as you mentioned, there are negotiations that go on where there is resolve. And so the strike is not the immediate thing that folks are turning to when they're having issues. So I want to be clear that I believe that is a tool in the toolbox, but there are many other things that happen before a strike occurs.
It is not, I understand it's not the first tool, but let me also emphasize that in this statutory setup that doesn't have strike and doesn't have unilateral imposition of a contract by the employer, it does give either party the independent power to declare impasse. So in effect, that's somewhat equivalent to a strike, because it says bargaining ends, bargaining is not successful, we need outside help, we need to invoke the statutory process that may ultimately lead to the VLRB imposing a contract. And so either party can do that, and that's a lot of power right there.
Elizabeth.
Thank you. Is VLRB backed up in caseload at all?
Again, yeah, to my knowledge, I'm not in the best position to answer that. I can say there are only 4 things pending right now from UVM.
I just meant in general. Do they have an extended time frame for caseload?
I think that's probably better directed to the VLRB,
Okay.
but having things that are pending since January would not be unusual. Some of them are pending because the unions asked for an extension of time in order to present papers or collect facts or do whatever they feel they need to do to best present their evidence in their case.
Who do you think has an easier time paying for a 13-month drawn out labor dispute? Which party in the case of UVM?
Well, I don't think that's, I think that's a question that's UVM continues to pay all of those employees during that time. The previous contract remains in full force and effect all of that time. Nobody gets a delay in terms of their paychecks, their regular paychecks. Most people are paid through automatic deposit into their bank accounts, and that does not stop. In this case, what didn't happen is they didn't get a raise on July 1st, which is the start of the new fiscal year and the start of the new contract time. But what they did get now and will get is retroactive pay for the pay that they lost for the increase in pay that they did not receive between July 1st and the present.
Thank you. I think you misunderstood my question, and maybe it's my fault because it's that time of the afternoon where I'm probably not articulating very well. But what I meant was, which party do you think has the better ability to pay legal fees in a 13-month drawn out contract negotiation?
I think neither party wants to pay legal fees, and I think both parties find that to be unfortunate. And I think that the unions collect dues, and they collect dues for purposes, particularly to represent the members of their union. And when representation requires use of a lawyer or benefits from use of a lawyer, that's when that's what those union dues are for.
Other questions of Sharon? Sharon, I've got just a few. First of all, I want to go back to SELRA. Remind me, after impasse is declared, and then the next step is mediation. Is mediation required?
Mediation is something we've always engaged in. I think it is an intermediate step that certainly is best practice. And whether it's required under SELRA, I would have to check because it's something we always want to engage in, and we always do engage in. Okay, so then there's fact finding. Right.
Was the fact finder a Vermonter or from out of state? Are they usually from out of state?
Both. This fact finder was from out of state. Several years ago, we went to fact finding with United Academics, and that fact finder was also out of state, but they're all from the Northeast. And then there are some that are also from the state on a list that the VLRB also maintains.
Are they academics? I mean, do they understand, or academic administrators, do they have any understanding of how UVM works?
Some do, and some don't have that experience.
Is after fact finding, what happened? Let's say, does either party have the ability to ask for binding arbitration, or is binding arbitration automatic, or what happens if the parties don't agree?
So in SELRA, the State Employee Labor Relations Act, which binds the University of Vermont, the state, and the Vermont State Colleges, that after fact finding, it goes to the VLRB. If the parties after fact finding can't resolve the issue. And so here, let me just back up. So the fact finder has a hearing, then there are typically briefs if the parties want to submit briefs. And then the fact finder comes out with a recommendation. At that point, the parties have the option to get together and talk some more with the assistance of having that fact finder recommendation in the background, to accept the fact finder decision, or to say we're not accepting the decision, and in fact, this talking more is not working. So there's I think a 20-minute period that allows for that. And if the parties don't resolve the matter following the fact-finding decision, then it goes to the Vermont Labor Relations Board, and each party prepares its last best offer, presents their last best offer to the VLRB. The VLRB also has the fact finder report and recommendation. The VLRB then has three choices. It can choose one party's last best offer in its entirety. It can choose the other party's last best offer in its entirety, or it can choose the fact finder decision. And what that does is provides finality. It also encourages both parties to really put forth what their last best final offer is, because if they don't, they're at risk of having the VLRB say, no, this particular provision of your offer is out of line with what we think is reasonable. The VLRB can't pick and choose from one offer and the other offer. It has to accept the offer in its entirety or reject it. So there's incentives for both parties built into that process, and there's always the backdrop of the fact finder decision also being one of the options for the VLRB.
Thank you. One other question. I'd just like to refine my understanding of something here. As I understand, we've heard testimony from other parties saying, yes, they believe in a balance. And I'm trying to better understand the regime where it's like the K through 12. That is the regime where you have safeguards, but in the end, the right to strike is on one side and the right to impose is on the other. If you were to impose what is your, if you impose a contract, well, then there's a contract and people are, would that take care of the health and safety concerns and the other concerns you mentioned because you were able to impose a contract?
No, because in imposing a contract, we can impose the terms of a contract, but the union would still have the opportunity to strike. And it's the striking in the context of UVM that would potentially cause great harm to individuals who aren't members of the union and individuals who aren't members of the university administration, but are being serviced by the university. So students who are getting their education, researchers who are in the middle of research that will be, that could be disrupted and invalidated if they can't continue it. Animals, both animals in the research context, but importantly, animals on and in the farms and the agriculture settings that the university has. Those are also serviced by members of unions. And so the strike context here that's what makes this different than a K-12 kind of context.
So the contract imposition for you, in your opinion, and I don't want to put words in your mouth, but I'm just trying to clarify. Your view is that the contract imposition really still leaves you equally vulnerable to consider to be the problems with the strike.
For a research university, yes, it does. It still does create not the same kind of balance that it creates in a K-12 context. But for H-173, it doesn't even provide an opportunity for the university to impose a contract. It's just a one-sided strike.
Any last questions of Sharon before we let her go?
Did you have an opportunity to watch the testimony that we've received so far?
I saw some of it. I think it was last week. I saw some of it.
Yeah.
Yes.
They had talked about the difference in negotiating from a union of people who are involved and affected and the things that they're fighting for, and Rep. Rose mentioned about the money, and I would love to at some point see kind of an outline of the money and the representation that UBM has in their negotiations at some point.
So if you'd like, I can review exactly what the what the economics proposed by each side were. If that's.
Yeah, no, I'm talking about the time and resources spent on negotiations with the unions.
Oh, well, as I said, there were 18 different negotiating sessions for both parties. And that does take a good amount of time on the part of the members of the union and a good amount of time on the part of members of the university administration and staff who participate in those negotiations as well.
But the college is having lawyers that are paid a certain amount of money to do that. So it's just talking about the power dynamic. I would love to see kind of what that looks like.
There's a legal advisor, if that's what you're looking for, but it's the university that determines the terms and the positions of the bargaining.
Does the university during the negotiations, are the negotiations carried out by university personnel primarily or by council primarily?
It's gone both ways depending on the circumstance. We now have more. It depends on the circumstance. So, for example, there's a negotiation going on right now with our graduate student union, a brand new union, and our chief HR officer is conducting those negotiations. So same way with the police union is, I believe, in negotiations now, and that's being conducted not by a lawyer. I believe the last time the United Electrical was conducted, that was not by a lawyer. That happened while I was gone last time, though, so I would have to double check that.
Thank you. Any final questions? Sharon, thank you so much for taking time to be with us. We appreciate it.
Thank you for giving me the time. And if anyone has additional questions, of course, I'm happy to provide additional information.
Thank you.
Thank you.
So, everyone, are we okay proceeding with our next matter? Our next is, we're continuing our hearing on H-169, an act relating to amending prohibition against discrimination in public accommodations and housing. And our first witness is Chris Delia. Chris, you want to join us? I think you know the members of the committee.
I do.
Sit down.
I've heard them introduced numerous times.
For years.
Every year, only you, Mary. Busy day for you, Mr. Chairman and committee members. For the record, Chris Delia, President, Vermont Bankers Association. Let me begin by saying that I apologize. I have to run up to House Healthcare on the medical debt bill as soon as I'm done here, but I will certainly make myself available to you, any of you, if you have follow-up questions after the hearing or at some point in the future.
Are you talking about 5 minutes, 10 minutes?
Oh, no, I'm going to get through it all. I'm going to take questions and then, but just as I'm done, I've got to get upstairs to go chat with those folks. So thank you for the opportunity to come in and testify on H-169. I'd like to start by saying and making a very clear statement that we support the passage of H-169. There is a section of the bill that I'm going to focus on, and that's the only section that we have a concern about. but again, support the passage of 169. I thought it would be helpful, Mr. Chairman, since probably many of you are not familiar with my testimony over the years in representing the banking industry, just to give you a quick overview of one of the areas that I've heard this committee talk about and proponents of 169 talk about, which is the Social Security number issue. So one of the things that you should be aware of under the Bank Secrecy Act, which was passed as a result of 9/11, banks are required to have customer identification procedures in place. We have to know our customer. And our regulators created a body of regulation associated with that, and our banks are examined on a routine basis to ensure that we are in compliance with knowing our customer. As part of that, we have to collect certain information on the individuals that we do business with. What I wanted to focus on is two sections for knowing your customer that I think are important for your conversation. And I'm just going to read a couple of lines here from this paragraph. For a U.S. person, a taxpayer identification number, or for a non-U.S. person, one or more of the following pieces of information: a tax identification number, passport number, and country of issuance, alien identification card number, or number and country of issuance of any other government-issued document evidencing nationality or residence and bearing a photograph or similar safeguard. I provide that to you because we, when we're dealing with foreign nationals, are not required to collect a Social Security number. We have to collect other identifying information that would help us to identify who those customers are. So again, I raise that because I've heard a lot of discussion about Social Security numbers and rentals, et cetera. And I just wanted you to know that we have two different groups that we deal with: U.S. citizens and those who are not U.S. citizens. And we look at different pieces of information that we collect.
But Chris, this is interesting. I just want to zero in on this.
Please.
I get not a Social Security, that I get. But banks under the Bank Secrecy Act are required to identify the nationality.
We are required to get documents that would help us identify the customer or the individual, and that by its nature is going to identify the nationality of the individual.
Didn't you read that nationality was part of it?
Yeah.
In other words,
I'll read.
have to reveal that they are not nationals.
Let me read it again so that we're clear on what I said. For a non-U.S. person, one or more of the following pieces of information: a taxpayer identification number, passport number and country of issuance, so that's pretty straightforward, alien identification card number or number and country of issuance of any other government-issued document evidencing nationality or residence and bearing a photograph or similar safeguard. Could be a passport,
Right.
could be a green card.
You think, for example, let's say I was from somewhere in Latin America, say,
Sure.
and I wanted to come to you to get a loan.
Sure.
And you said, let me see some ID, and I gave you a tax ID number.
Sure.
Do you have to ask me any more questions about where I'm from once I give you the ID?
They're going to ask for multiple pieces of information to ensure they fully understand who the customer is.
Yeah.
It's not just one piece of information is going to do that.
But under the Bank Secrecy Act,
Yes.
if I gave you a tax ID number, that would be the end of it. Under this, you would have complied with the bank.
We comply with the Bank Secrecy Act if we have enough information to identify that you are Mark Mahali and that you have given us the information we need to verify that.
Okay, thank you. Sorry to interrupt.
It's just, I want to be clear, it's just not one piece of
All
information
right.
that we would be looking at.
Okay,
Okay? So in the conversation regarding this particular bill, the area that I'm going to focus on is on page 6, lines 10 through 17, and specifically line 14. I want to take citizenship right off the table because that is not an issue for us. We deal with individuals who come from Canada and other locations who provide information to us, who help us identify their citizenship. And that is not an issue whatsoever.
So in other words, keep it in the bill.
I'm fine with citizenship, not asking for it to be taken out. It's the immigration status piece where it becomes a little squishy and challenging for us. So let me read a couple of other items for you and explain the background related to it. So in our world, we have the alphabet soup of regulations from A to double G that we're at right now of regulations we need to comply with at the federal level. In this particular case, we're looking at Regulation B, which is equal credit opportunity. That's what governs fair access to credit for financial institutions. In this particular case, we're looking at, and I will give all of these citations to you. I think Representative Dodge has them, but I will give them to you as well. We're looking at a particular section in Reg B that states a creditor may inquire about the permanent residency and immigration status in the United States of an applicant or any other person in connection with a credit transaction. So we as an institution under the regulation have the right to ask that question. We then go to another section of Regulation B, which talks about the use of the information. In the use of the information, a creditor may consider the applicant's immigration status or status as a permanent resident of the United States and any additional information that may be necessary to ascertain the creditor's rights and remedies regarding repayment. What that means is you are looking at the ability of the applicant and the risks associated with that applicant's ability to repay the loan that you are going to put out there. Now, in today's environment, it is unfortunate that we find ourselves in these types of discussions with changes and discussions that are happening at the federal level that are not comfortable. But it's a credit risk analysis. And I think the only way I can explain it to you is we see what happens on the news. We see what's happening out there with the immigrant community. And the credit risk analysis becomes much more difficult and heightened. Because if I make a loan to the chair and the chair 2 weeks from now may be deported, what's the credit risk of being able to get repaid on that loan? That is the reality we find ourselves in. We are not in the immigration business. We don't want to be in the immigration business. But if we make a loan, there is the expectation that the loan is going to be repaid. So that's part of the analysis. It's all about the rights and remedies regarding repayment. There's a couple of other things I want to make you aware of, and then I'm happy to answer questions. When you're a lending institution, there are a couple of options when you're out making loans to customers in the marketplace. There are institutions that have internal portfolios, in which case I make the loan to Representative Howard, and we hold that loan within the bank, within our portfolio. There are others who not only do that, but they sell in the secondary market, and I'll explain that in a minute. And then there are others who only sell in the secondary market. So that's the group I'm going to focus on. When you're selling in the secondary market, these are to organizations like Fannie Mae or Freddie Mac, still under the control of the US government as a result of the financial crisis in 2008. But it also includes rural development. It also includes the Federal Housing Agency, the Veterans Administration. You as a financial institution have to warrant that that individual is here in the United States legally, both for Fannie Mae and Freddie Mac. They will not buy the loan if that's the case. So when I'm a lender who only does portfolio lending, I have no product to offer an individual regarding immigration status. So when we look at Reg B, when we look at selling in the secondary market, the concern is how is that denial going to be viewed by the applicant? And we've seen enough conversations through time in the legislature that individuals will claim discrimination when it is not discrimination. There are always two sides to a story. So for these reasons of access to credit in the market, Reg B considerations, what's happening at the federal level, we're not comfortable with immigration status in parentheses 6 as you have it right now. We would ask for those two words to be removed. We are fine with every other section of the bill as you have it before you.
Thank you. Questions? Yes.
Yes, so I appreciate, this was a concern that you had brought up to us, to the chair and to me, and I have been trying to wrap my head around it, because there's still federal language that prohibits discrimination based on immigration status, which I know that I sent your way.
May I ask, Representative, are you referring to the CFPB and the Justice Department?
Right.
Okay.
Yeah.
Yep.
And so the CFPB stands for the Consumer Financial Protection Bureau. And so under federal law, the Consumer Financial Protection Bureau and the Justice Department issued a joint statement that reminds financial institutions that all credit applicants are protected from discrimination on the basis of national origin, race, other characteristics covered by the Equal Credit Protect Opportunity Act, regardless of their immigration status. And while the Equal Credit Opportunity Act allows a creditor to consider an applicant's immigration status when necessary to ascertain the ability to repay the creditor's rights regarding repayment, creditors should be aware that overbroad reliance on immigration status can run afoul of the law. And so, I looked up the New York and the Washington laws about that added citizenship or immigration status, and I can read, like, Washington State has wording that says the right to be free from discrimination because of race, creed, color, national origin, and adding citizenship or immigration status, right to obtain and hold employment without discrimination, full employment of accommodations, the right to engage in real estate transaction, and the right to engage in credit transactions without discrimination. So Washington State has it. New York State also has language that says it shall be unlawful discriminatory practice for any person, for any basically landlord or proprietor, agent or employee to discriminate, to deny a person any of the accommodations, advantages, facilities, or privileges thereof, including extension of credit based on all of the protected categories, including citizenship or immigration. And so it seems like the feds are requiring that you know that you identify, that you can affirm identity of a borrower. They're also saying you can look at their economic likelihood of paying you back, but you can't base that decision entirely on whether the person is a single parent, whether the person has a disability. I mean, if we are at the point where we are not gonna do business with somebody because they might get deported, it just seems a little like, why couldn't we then discriminate against a whole host of people who we've decided we need to actually put into law some protection for them, because we do tend to run to that, we do tend to think of this person as incapable of paying, as opposed to simply doing what the feds have said, which is actually look at their economic picture. If this is somebody who's got a great
But
a job, et
I
cetera.
think there's a question in there.
I'm just very,
I think it
I
would,
think the two
Well, I
questions
think
in
it's-
there are,
Yeah.
one, Chris, one
this is why
question
they pay
is,
him the big
what
bucks.
are the same big bucks you're making?
How do I-
What is your thought about what appears to be somewhat contradictory position of the federal government?
sure.
And number two, given the regime that you cited, well, what's going to go on in California and Oregon and wherever, New York,
Illinois, yeah.
Okay.
right? And a fair distillation of the question.
Right, yeah, and how would we not have risk imposed on banks for all of the protected categories?
Well, first of all, we're not in the discrimination business.
Yeah.
If we were, you would be hearing about it. Our regulators come in and examine us often to ensure that we're not discriminating. And I continually ask the question when my friends from the Federal Deposit Insurance Corp are here every year, what are you hearing in Vermont? And the answer is nothing. So I'm proud to say we're not in the discrimination business. And of course, we would look at all of the factors associated with anybody. My statements today would in no way prohibit anybody from walking into an institution today or tomorrow to try and apply for a loan. And the factors that they would consider would be applied. I would suggest, Representative, there's a very important distinction with the CFPB and Department of Justice document. It is a joint statement. And I'll read the bottom of that joint statement. This document is for informational purposes only. It does not impose any legal requirements, nor does it restrict the agency's exercise of their authorities or confer rights of any kind, and it is not enforceable. A statement does not have the weight of rule, regulation, or law. And that's what our institutions will follow. Our institutions will not have a pervasive policy regarding immigration status in the way that's suggested. As far as what has occurred in other states, each state being different, each legislative body being different, each organization in my world being different, I can share with you that as we all do, we recognize what the tea leaves are telling us, and where you may choose to argue vigorously, die on the sword, or not argue at all. What I shared today are the perspectives of my members who want to serve a community, my members who are very familiar with the community you're representing, because I have a lot of folks who do ag lending. And this is an important community to the ag folks. So we're aware of it, but I have to represent what they're telling me. And the concerns are immigration status as proposed in the bill, we see as problematic, but would never prevent somebody coming through the door to be considered for credit or getting access to credit.
Chris? All right. Well,
Yes, sir.
You have a question?
Well, it sounds like you're already following the practice that we are just trying to codify.
We're following, I'm sorry.
Yeah, no, I mean, it sounds like if the representation is that the banks in Vermont do not discriminate, would not discriminate based solely on immigration status, then codifying a protection, if anything, protects us from, when we make a state law, it protects us against federal impositions, with a caveat of unless the federal funds that back a specific product, like you said. I mean, the bill could certainly, and I think already has a notwithstanding, or could contain the caveat for, obviously like in the public housing world, when there's a HUD or some kind of housing that you do have to have citizenship, we wouldn't want to stop people from having access. So I think that you would, from what it sounds like, Vermont banks would not suddenly be sued because people would have no reason to claim
Well,
discrimination. Because
I wish I could share your enthusiastic view. I have seen people sit in witness chairs and make claims about discrimination. And when you hear the other side of the story, it's not discrimination. And what my concern is here is that credit analysis being done could be viewed as discrimination because of my immigration status. And therefore, my banks feel that they would be in a very difficult position if that were codified in the statute. And I cannot answer today, fortunately, what may happen tomorrow as a result of this new administration we have and have to come back and deal with an issue that you've codified in statute that is now problematic because of potential federal changes. So it's a tough environment in this particular issue that you're trying to deal with.
I have a couple of questions for you.
Sure.
Which I want to focus on the same two issues you raised. One is that the Reg B language that says the creditor can inquire into immigration status and consider it as part of the analysis of ability to repay. I think we'll be talking to our legislative council.
By all means.
Because the question there is, can Vermont be more protected than the federal regulation? Because Vermont could, if the answer is yes, we can, as we often are, we could simply say, well, no, they can't consider that. And then you wouldn't have to worry about discrimination lawsuits because it would be prohibited. Right?
As long as we're looking at, as long as your public policy discussions recognize that we have a federal body of regulation
Said you may, right.
that we have to adhere to, that my concern would be we don't create any conflict between what you would like to do here in Vermont with regulations that we need to adhere to.
I understand. I am very concerned about the portfolio loan versus Fannie Mae issue. And as I understand your testimony, while a lot of banks sell most of their loans, they don't, and they also have portfolio loans. But your testimony is there are some banks
There are some who
that
do
do
not.
not do portfolio loans.
That's correct.
Are they our major banks, like, our major commercial banks here? Do they not keep portfolio loans?
So you have to understand the banking system is a spectrum, if you will. In Vermont, you go from very large institutions down to the smaller community banks in our state. The community banks are the ones that are typically selling in the secondary market because that's how they recapitalize their loan portfolios to put more money back out in.
But so they don't, so Community National or something like that, they don't do portfolio loan. They don't have portfolio.
I would not want to name names on the record, but we have institutions that do not do portfolio lending and only sell in the secondary market.
So so no matter what we say or we don't say, under current law, the need to warrant Fannie Mae, their form loan
Yeah.
requires that the lender to sell in, that the lender has to warrant that they're a legal resident.
Yeah, I can read two sentences for you that I think might be helpful. So this is under Freddie Mac.
Yeah.
A mortgage to a non-US citizen who has no lawful residency status in the United States is not eligible for sale to Freddie Mac.
Right. Okay.
And then under Fannie Mae, you've got by delivering the mortgage to Fannie Mae, the lender represents and warrants that the non-US citizen borrower is legally present in the country.
So say, for example, I mean, I don't want, you can always tell me, Mark, I think I'll think about that. I'm not going to answer you. Okay.
I reserve the right to.
You reserve the right.
That's my counsel.
Supposing that we decided we didn't want to take out status, immigration status. And in that world, supposing that we said something like that a decision by a bank not to take the loan because they can't sell on the secondary market is not considered a violation of this section. Would that help?
I'm going to follow your lead, Mr. Chairman, and get back to you on the answer. I'd like to, I think I'd like to think about that a little bit more.
Okay, great. Anything else? Any other questions for Chris?
You're crafty. I've seen you work before.
Did you have a question, Tom?
No, yeah.
Anybody else want to give this guy a little brief?
He's been an excellent on this.
I would just like, oh. That's the cookies talking.
Mr. Chairman, after 22 years, this is not great.
I know.
No, that I will speak half cookie and half, some carrot and some stick. I will say that, I know of countless, migrant workers who feel safe going to our Vermont banking institutions, feel respected, and feel served when they're making deposits into checking and savings accounts. And I think that it's only fair then that if they are trusting and respecting the banks to take their money, that banks and credit unions do, like New York, Washington, California, and other states that do the same with their money extending to people so that they can build a life and form part of the economy as taxpayers and as people who pay into Social Security and as people who are going to build us out of our housing crisis. So
Thank you. Thank you, Chris. I appreciate it a lot.
Thank you.
Our next witness is going to be Will Lambeck, organizer from Migrant Justice. Will, please come up and tell us what you, say your name for the record and tell us what you think.
Thank you, Mr. Chair. For the record, Will Lambeck from Migrant Justice. And if it pleases the committee, I'll be interpreting for Jose Ignacio, and perhaps we could start with him, and then I may have some additional remarks.
Okay, Jose Ignacio de la Cruz. Bienvenido.
Gracias.
this is where you guys all get jealous. 'Cause
I know.
Entonces,
Bueno, pues me voy a presentar. Mi nombre es
diga su
José.
nombre. Comienza, por favor, con su nombre.
Mi nombre
Begin with
es-
your number. Begin with your name.
Sí. Mi nombre es José Ignacio, soy líder con Justicia Migrante y soy parte de la comunidad de aquí de Vermont.
My name is Jose Ignacio. I'm a leader with the organization Migrant Justice, and I'm a member of the immigrant community in Vermont.
Soy un trabajador y parte de una cooperativa que se llama Nuevos Marcos, donde construimos viviendas ecológicas y sostenibles.
I'm a member of a workers cooperative in Vermont called New Frameworks that constructs accessible and sustainable housing.
Sí. Me da mucho gusto al saber que a una persona pues va a tener un techo en su cabeza cuando terminamos una casa.
And it brings me great pleasure that when we finish a job, we know that we've built a new roof that will be over somebody's head.
Sí. Y pues hoy quiero hablar de los retos que enfrenta nuestra comunidad inmigrante aquí en el estado de Vermont.
And today I want to speak with you a little bit about the challenges that our immigrant community faces in Vermont.
Pues en el tema de la discriminación en cuanto a la renta y acceso a la vivienda.
Related to discrimination in access to rentals and housing.
Pues el simple hecho de no tener un seguro social pues hace casi imposible que nuestra comunidad no pueda conseguir una renta o casa o apartamento.
The sole fact of not having a social security number makes it almost impossible for members of our community to obtain an apartment or a house.
Sí, pues ya que en cualquier lugar que aplica uno, pues si no tienes el seguro social, pues o no hablas inglés, simplemente tu aplicación es ignorada y jamás te llaman.
Because wherever you go, if you don't have a social security number, you don't speak English, your application is ignored and you never receive a response.
Sí, y pues les voy a comentar una parte de mi vida, pues que pues al salir de un rancho, yo estuve trabajando por 5 años en un rancho y al salir de un rancho, pues quise buscar una casa digna para que mi familia pudiera descansar, pero pues no encontraba.
And to illustrate the point, I want to share a little bit of my personal experience. I worked on a dairy farm for 5 years and lived on that farm. And I decided I wanted to leave to pursue new employment. And in leaving, that meant I had to find housing for myself and my family. And I wanted that housing to be dignified so that we could live there. But it was very difficult to find.
Sí, pues cuando metíamos las aplicaciones, entonces siempre nos pedían el seguro social y pues no, a las personas no les importaba si teníamos dinero para pagar o no, simplemente es el seguro social.
Because everywhere we went, they just asked for our social security number, and it didn't matter if we could demonstrate that we had the ability to pay. They only wanted to see a social.
Sí, y pues cuando salí, pues yo estaba decidido a trabajar en esta compañía que estoy trabajando ahora, pues llevo 4 años y busqué la oportunidad con un amigo para que nos apoyara y nos dejara vivir en su casa.
But I was determined to leave the farm because I had this new employment opportunity that I wanted to follow. And it took a long time, but finally, through the support of a friend, I was able to find the house I'm at now.
Sí, y entonces con mi amigo tardé viviendo un año, entonces en ese año igual estuve metiendo como unas 20 aplicaciones, recuerdo, y también fuimos a ver varias casas. En una de esas, pues fui con un amigo y compañero de trabajo que me fue a traducir.
But before ending up where I am now, I had to crash with a friend for about a year. And during that year, I think I applied to more than 20 different apartments. And one of those, for example, I went with a friend and coworker to interpret for me.
Sí, cuando llegamos a la casa nos recibió una señora muy amable y nos mostró la casa. Y cuando íbamos mirando la casa, iba platicando con mi amigo y también le iba comentando sobre el seguro social mío, si yo tenía seguro social.
And when we arrived, the landlord was very welcoming. She was very nice with us. She began to give us a tour of the apartment. But as she was giving the tour, she directed her comments to my friend and started to ask him if I had a social security number and what my immigration status was.
Sí, y mi compañero de trabajo pues no quería como decir que yo no tengo un seguro social. Entonces él decía, pues él es mi socio, estamos trabajando en una cooperativa juntos y él tiene dinero para pagar la renta y estar muy cómodos aquí. Y entonces al final de varias pláticas, él tuvo que decir que yo no tenía seguro social.
And my friend and coworker at the outset didn't want to have to respond to those questions. So he tried to deflect by saying, look, we work together. Here's this employment history. He can pay for the apartment. He has this money. But the landlord kept pressuring and pressuring until at the end of the tour, my friend felt like he had to respond that no, he doesn't have a social security number.
Sí, y después que dijo eso, la señora inmediatamente como dijo, oh, los dueños de esta casa viven un poco más arriba y ellos son los que vienen en verano porque ahora están en Florida, como era invierno en ese tiempo, dice, ahora viene en verano y van a estar como conviviendo con ellos y si ellos tienen algún problema y el idioma va a ser una dificultad. Entonces mi amigo le dijo, hey, yo vivo a 5 minutos de aquí, yo puedo traducir las veces que sean necesarios para ellos. Y no quiso la señora rentarnos la casa al final del día.
And so when the woman heard that, and excuse me, going back, the woman in the question is not the landlady, but the property manager. And so when the property manager heard that, she said, "Oh, well, the owners of the building, they live upstairs. They come back during the summers, and if your friend doesn't speak English, I don't think they'd be able to communicate. So maybe it's not the right fit." And my coworker said, "No, it's not a problem. I live 5 minutes away. If there's a language barrier, I can swing by and interpret."
Sí, entonces, pues en ese año no encontré ninguna renta y pues ya me tocaba salir igual de la vivienda que me había dado un amigo. Y por suerte un primo tenía un látigo desocupado y entonces nos fuimos a vivir ahí y era verano, había mucho calor y nosotros teníamos un bebé en ese entonces de 1 año.
But that was the end of that. So I kept searching. I had crashed with my friend for a year at that point. I had to move on. I found a cousin who had an attic that was unoccupied. So my family, and at that time we had a 1-year-old baby, we moved to live in this attic.
Sí, entonces no podíamos tener electricidad en el ático por un riesgo de un incendio. Entonces recuerdo que mi niño lloraba por las noches porque tenía mucho calor y lo que teníamos que hacer era soplarlo con un cartón para que dejara de llorar un rato y pudiera descansar y con miedo que le pasara algo también a él.
And because we were squatting in this attic, it didn't have electricity, and they said because of fire risk, we couldn't run cords up. So this was during the summer, we couldn't put a fan in. And so I remember all through the night having to fan my 1-year-old with a piece of cardboard to keep him cool enough.
Pues después de mucho esfuerzo pudimos encontrar pues algo, una casa donde podíamos rentarla porque también un compañero de trabajo me dio que iba a firmar el contrato conmigo prestando su seguro social porque él tenía una propia casa y él podía hacer eso.
And finally, after all that ordeal, we were able to find stable housing only when a friend of mine who has a social security number says, I'll put my name on the lease for you and I'll use my social security number. And that's when we were able to rent a place.
Sí, y la condición para firmar el contrato que nos pusieron fue que teníamos que pagar 1 mes de renta, 1 mes de depósito y el último mes de contrato de renta. Entonces fue mucho dinero, pero lo teníamos que hacer porque ya queríamos tener una propia casa para vivir.
And to move into that place, we were required to pay first month, last month, and a security deposit, which was a lot of money. But we did it because we knew that we needed to take advantage of this housing that was on offer.
Sí, sabíamos que no era algo bueno para nosotros, pero decidimos hacerlo porque mi familia ya no podía estar viviendo en esas condiciones.
We knew this wasn't the best option for us, but it was the only option because my family couldn't keep living in the conditions in which we lived.
Y sí, pues como mi historia, pues hay muchas historias similares a la mía. No soy la única persona que ha pasado por eso o está pasando todavía por esto. Entonces, pienso que sí, que le queremos pedir a los legisladores que pasen nuestro proyecto de ley, pues H169.
I know my story is not unique. There are many in my community who have gone through the same things that my family and I have gone through. And that's why we're asking the legislature to please pass this bill, H169.
Sí. Y como dije al inicio, pues nuestra comunidad está ayudando a crecer el estado de Vermont. Estamos construyendo edificios, carreteras y casas, etcétera. Entonces, siempre nuestras manos han estado aquí para todo el estado y pienso que es injusto que nosotros construimos las casas y no tenemos tampoco ese acceso a una vivienda.
And as I said at the outset, my community is helping the state to progress. We're building the homes, the buildings, the highways that are necessary as Vermont moves into the future. And it's unjust that the state relies on our labor to be building these things, but doesn't allow us to live in the houses that we build.
Sí. Pues llevamos años como comunidad viviendo esto y hace 2 años también decidimos levantar la voz para que pasar a un proyecto similar al que estamos pidiendo. Entonces, creo que no es la primera vez que estamos aquí y siento que ya es justo y necesario que nos escuchen y hay muchas personas más afuera también, no solo soy yo aquí.
And this has been an issue on our radar for a long time now. We were also at the legislature last year asking for the same protections. And we think that it's fair and just and necessary that the legislature take this action. And finally, I'll just remind you that I'm not here speaking just on behalf of myself, but supported by a large community who's here as well.
Muchas gracias por escucharnos y por darnos la oportunidad.
Thank you very much for listening to us.
Thank you.
And
Questions that you want to ask Jose Ignacio, or shall we? Okay, go ahead, Will.
Thanks very much, Mr. Chair, members of the committee. I'll just add a couple of things on to Jose Ignacio's testimony. And as he says, there's about 50 folks crowded down in room 10 who are watching the live stream today and at a press conference in the Cedar Creek room earlier. We didn't want to try to pack us all into the room. It's hot enough as it is. But this is something a lot of people are paying attention to. So I'll just add a couple more things. As Nacho said, there's widespread discrimination with a real impact. So not only is it the pain and the humiliation of being denied housing, but that is limiting Vermont's workforce development. There are people who want to be in the state, who want to be contributing and who are unable to because of housing discrimination. That also means that the few opportunities that immigrant families have for housing are oftentimes tied to their employers. And that's something that harms both businesses, which have an additional expense and administrative headache. You want to be an employer, you don't want to be a landlord. And it also harms workers whose employment is now tied to their housing and puts them at greater risk of abuse and exploitation. And the principal mechanism that in which this discrimination occurs is through the request of a social security number and then denying applications when one is not provided. But we've also heard from landlords who don't currently request a social security number in the application process, who don't see it as relevant or necessary. And these landlords, in addition to not wanting to discriminate against potential tenants, also understand the security and privacy concerns. They don't want to be collecting many, sensitive documents and having to maintain those. And not only is this something that some landlords in the state do, but this is a common practice outside of Vermont. It's certainly not the case that landlords everywhere in the country have the need to request a social security number. So prohibiting the request of a social security number wouldn't create a new practice. It would just incentivize a practice that is already happening. But we do also recognize that many landlords currently do request a social security number, not with the intention of discrimination, although sometimes that is the de facto impact, but for relatively innocuous reasons of wanting to perform a credit check or a background check. And we want to be clear, it is not the intention of this legislation, and we don't believe it would be the impact to prohibit background and credit checks. And we think there's been some unfortunate misinformation about this that's confused the matter. We know on Friday you heard testimony from Champlain Housing Trust, one of the largest landlords in the state, that they would certainly be able to conduct credit checks without a social security number, without much additional cost or complication. And it's our understanding that perhaps some landlords would need to download a new app or switch to a new company, but we know that there are companies that provide these services to conduct credit checks without a social security number. So we certainly are open to compromise in good faith, and we've seen the amendment that has been offered by Champlain Housing Trust. Migrant Justice fully supports that amendment. We think that would help to avoid any potential unintended consequences of the bill, limiting federal benefits that applicants may apply for. So we fully support that. And that's a great example of how this bill can be improved through the collaboration of our stakeholders. But we would be hesitant about considering other amendments that would limit the protections against discrimination. And finally, just regarding the previous testimony that you heard, these are concerns that Microjustice has been aware of for quite some time. We agree with you, Mr. Chair, that Section B doesn't require banks to consider immigration status. They just permit banks to consider it, and we think Vermont can and should have a higher standard on that. And regarding the secondary mortgage markets, to be very clear, this bill would permit banks would permit them to request immigration status. They just can't discriminate based on immigration status. Representative Dodge read statutory language from a number of other states that have put these protections. And New York, for example, prohibits discrimination in mortgages, similar to what we're trying to achieve in Vermont. And I think New York's banking industry is in pretty good shape. And if there were a rash of nuisance lawsuits or unfounded litigations against New York banks for discrimination based on immigration status, I think the committee would have been presented with that evidence. And if it's not happening in New York or other states with these protections, there's no reason to expect that they would happen here. Thank you very much. So that concludes our testimony, and happy to answer any questions.
Questions, Will? I have a question, Will. So going back, you said it's okay if banks request the immigration status. They just can't discriminate on that basis, correct?
That's right. And in that, I'm referring to page 8, subsection D, essentially the last part of the bill, which is this carve out that.
Right. The carve out, right. Is here's another question.
Can I just?
Sure, go ahead. Oh, I'm sorry. No,
Alexandra
it's here.
busy at 3:30.
Yeah. So we have to, I'm thinking we should go out of order.
Yes.
Yeah. But
3:30 is in 10 minutes. Just
oh, she's busy at 3:30.
yes.
She has 10 minutes left.
Okay. Oh, I think what we'll do is, can you hang around? Say, thank you.
Thank you.
Thank you. Thank you.
Thanks, Sarah.
Thank you. Alexandra. Hi, we understand you're short on time.
I'm actually a little more flexible now, so I would have maybe an additional 5 to 10 minutes past the
Well,
original time.
That's still short on time for us.
Okay.
So I'm going to dispense with the committee introducing itself to you and go right to your testimony. Please tell us your name for the record and go ahead.
Yes, Alexandra Alvarado.
And do you know the background of what we're doing? She does. Okay.
Yes.
So tell us whatever you want to tell us.
And maybe can I just make a small request,
Yes.
Chair? Can you just tell us who you're representing, like what it is that you do and your experience, like why you can bring some light with your testimony to this question?
Sure. So I'm the Director of Education at the American Apartment Owners Association. We have over 150,000 landlord members nationwide, and part of my job is making sure our members are notified and educated as to all of the laws that are occurring. And also we provide tenant screening, legal forms, and other education services. So when it comes to tenant screening, I know quite a bit, and I know that was probably one of the concerns that might have come up with this type of bill, as it did when other bills in California or Illinois were passed, New York as well.
Oh, go ahead.
Okay, great. So I think really a lot of the landlord concern comes from being able to inquire into immigration status in the sense of, can they actually verify their identity without a social security number? Can they also assess their financial history and their credit history without a social? Can they do it also for criminal and eviction records? So in that sense, it is a concern for landlords. However, being from a tenant screening company, I can say that there are ways to work around that. We already do that currently for our clients in California, New York, Illinois, Colorado, and so on. Essentially, for credit reports, most of the time, if someone comes to this country, they can get an individual taxpayer identification number, which is an ITIN. They can use that number to establish credit here. They do not have to have a social to establish credit. And just like any other applicant, if they don't have credit history, then it's up to the landlord to decide whether or not they're going to accept an alternative form of them showing financial responsibility, or if they're just going to create a policy where they do require credit history. And that doesn't really touch on immigration status per se, but if that person has established credit, they should be able to still obtain a credit report. The other part of it, which is the background check. So for criminal background checks, we actually don't use a social. Most tenant screening companies do not. Name and date of birth is typically all that is needed to do a criminal background search. So there should be no effect to finding out if a rental applicant has a criminal history. As far as eviction records, that one is a bit trickier. Eviction records do not have a social or date of birth. So what we do is we rely solely on obtaining as many addresses as possible on the applicant, and we use the social to obtain those addresses, or the credit history. That becomes a little difficult if we don't know where they've lived, because we can only check the addresses that we're made aware of or that we are able to find. In that sense, it can be limited, and evictions are not part of a credit report since 2017 either. So there are some challenges there, but that doesn't really have to do with immigration status. It's just a challenge that we always have, is if we're able to find addresses, we get a more accurate search. If not, then, unless you go directly to that court, it's going to be difficult to find if that person has an eviction record. And that's a challenge across the industry.
Let me just ask you, I want to make sure I understood correctly.
Sure.
Okay. You don't use social security numbers for criminal.
Correct.
For eviction records, you use prior addresses. Did you say
Correct.
that you need the social security number to get the prior addresses?
That's the best way to do it. Or if they have credit history, there should be a list of addresses on their credit report. So we take not just those addresses on the credit report, but also any addresses that we identify through their social. So anytime they've used their social, if there's been an address associated with that, that's what we're pulling. And then we're checking to see if there were any evictions at those addresses with the applicant's name.
So one workaround is to use the credit report, which in turn you're getting with tax ID, for example. Right?
Exactly. Yes. Yes. And then that would allow us to still have access to addresses other than the one that is entered by the applicant. Usually they're going to be required to provide at least one address on their application. So we use that one. But then if we're able to find more, that's better, because we can check all of the addresses that they've lived at. So that's why the credit report becomes important. And I think what we've seen now with California specifically, they started doing rent reporting so that tenants can start to build credit. I think that's another issue that's separate from this, but that, in general, immigrants and also a lot of Americans here do not have credit history, which makes it difficult for them to obtain rental housing. So that's a separate issue, but, if they do have credit history, and then we should be able to find some addresses that we can check.
So were you saying that, you were just saying you have some program that helps with credit history?
No, yeah. So that would be in California recently, a law, AB 2474, I believe, or was just passed, that basically has required landlords with 15 or more units under management to report or offer the option to report a tenant's rent payments to credit bureaus, so that as they pay rent, they build credit. Just as they make payments on their credit card, the payments that they're making on their rent would go towards their credit score should they choose to do it. They would pay for it in most cases. It's optional, but the landlord can charge them up to $10 for that service. So essentially, they start to build credit over time. And hopefully that allows them to then be more eligible for, regardless of immigration status, for really anything, including home ownership in the future.
Questions of Alexandra? By members of the committee? Any questions? Go ahead.
Okay.
Oh, you want to go on,
Yeah,
Alexandra?
go ahead.
I didn't mean to
I
interrupt you.
was, no problem. Although maybe this would be a good place for a question, but I did also want to mention the second part of really the concerns. So one of the concerns is, are we able to do a thorough investigation of the applicant? The second part is, if they end up leaving owing us rent, are we able to pursue that debt? That is a big concern as well. Obviously, there are tenants who unfortunately may leave owing quite a bit of rent and try to disappear. So one of the ways that landlords are able to track tenants is by using their social, so that they can get those rental debts and even serve small claims court orders, whatever it is. So that tends to be something that can prolong the process and is a concern. It's not impossible. So if a tenant owes money, you can still report that debt as a collection on their credit report without needing a social or without necessarily needing their permission. However, it becomes harder to identify the individual if you don't have a social. So that's part of the reason why landlords also want to make sure that they have a social, and they are afraid that if they are requiring that the individual have a social, that then they are requiring that they be of a certain type of immigration status. So that's really where it becomes trickier for them. It, like I said, is not impossible. And if the person did have a social, then, they could ask the judge of a small claims court case to order the tenant to provide it. So that is possible in most states, but it's that extra step and uncertainty of just not knowing who they are exactly, because it's harder to either garnish wages or levy a bank account. Obviously, collection laws vary by state, but in states where that is available, it's usually required that there be a social to enact that. So it complicates the debt collection process. Make it impossible.
Is it a question of complicating it or making it impossible?
It's not impossible, but it does complicate it. So they could still, like I said, report a collection to their credit report without the social, but they have to be able to show that it is that individual. So collection agencies are good at doing that. They usually have things like skip tracing, which allows them to backtrack and locate the applicant or the tenant's details using their phone number, for example, or date of birth. So there's ways that you can locate someone to pursue that debt, but it's not as straightforward. If you have the social and it's that person's social, it's very much like clear cut that it's that person, and you can now, in a lot of states, garnish wages and levy their bank account if needed, using a collection agency to do that process.
Thank you. I don't want to interrupt you again. You have more?
Yes, I have one last point. I think really the last point is the legal risk issue. So clearly, landlords, housing providers are always concerned about having an increase in lawsuits or saying the wrong thing by accident. So far, we haven't seen any major cases against landlords who have accidentally asked for immigration status or hinted at it. But more so, we've seen some of those big hallmark cases on landlords that are threatening to call federal authorities or immigration authorities on a renter that they know is here illegally because they didn't pay rent. And so they use it as a form of leverage. That has been pursued in some major cases in New York, California, I believe, I want to say Chicago as well, but I'm not too sure about the Chicago one. In any case, though, the point is that they are worried about it. They don't want to be pursued for making an accident. And I think ultimately they still want to have the ability to collect a social if it is provided. So they want to be able to ask for it. That would really help them to, for those that do have a social, they can then go through all of those steps. And then for those that do not, they can then find some alternatives to verify their identity and go through all of the financial verification. But they should still be able to ask for it. I think that's really what they're concerned about, is that they can't even ask because they might get sued. So that's something that the law isn't super clear on, at least in California. So it has caused some concerns among landlords when they have tenants applying as to what they can or cannot ask them. It's not super clear.
Thank you. Is there any questions? This has been most helpful.
Yeah, can I just ask a very quick one? I understand that California actually passed, do I have this right? That California passed a law that essentially bans cities from passing ordinances where they would require landlords to compile and report back immigration status. So I know with the sphere of a landlord being sort of held accountable for holding somebody, for whatever the word would be, harboring, I guess, somebody, that that it looks like California actually passed AB 976. Do I have that one right? Anyway. Oh, no, it's not. It is AB 299 from 2017. AB 299 Calderon that actually bans cities from in an attempt to get, I guess I'm trying to say that sometimes a state will try to legislate ahead of perhaps federal pressures that they see on the horizon of some kind of imposition, a federal imposition. And I know that in this building, we are currently doing a whole lot of that in an attempt to strengthen our state, use, our legal recourse to defend our residents and our businesses. So I think that the fear should be, prompting us to actually act rather than to not act.
I just want to make sure I heard your last piece of testimony. You were saying, ideally, you'd like to see it so that landlords could ask for a social security number routinely, but then if one wasn't available, accept alternative forms of ID. And that some landlords are worried that merely by asking for a social security number, they could be accused of discriminating. Am I getting it right?
That's correct. Yes.
Okay. Any other questions of Alexandra? Hey, thank you so much for taking time to see us. And your testimony has been most useful.
Thank you for having me.
Okay, take care.
Take care. Bye.
Will, could you come back up for just a minute? I'm sorry we had to interrupt your testimony. Will made a number of points. Do members of the committee have any questions? I just want to make sure you get your shot at him if here he is.
In the flesh.
I guess I just have one question. Speaking for myself, one thing I'm hearing is that it's a lot easier if you have a social security number and you're a landlord. And another thing I'm hearing is we really need people to be able to accept some alternative form of, like, a tax ID number, not a social security number. One option is to make it clear that landlords, and it's probably a reality that for many landlords, 99% of what they do doesn't involve someone who has a social security number, but you're concerned and we're concerned with those who don't. So obviously one solution would be to say that landlords must accept an alternative form of government issued ID as an alternative to the social security number. without prohibiting them from asking for it concept. But I know that might, be kind of a pressure. I don't know. What's your thoughts on that?
Thank you, Chair, for the question. And certainly that's something that has been considered this year and last year when the proposal was first put forward. The way that the bill is currently drafted is certainly preferential and prohibiting the request of a social security number because were it simply to be made optional, of course, the concern is the allowance of de facto discrimination. And it's very difficult for prospective tenants to have that burden of proof of, well, I left that field blank and I never got a call back. And I don't know whether or not they discriminated against me, but in essence, the applicant has been obliged to provide evidence, or not evidence, but at least inference of immigration status by the presence of the optional field of a social security number. So I think people's experiences, even if that field were to be made optional, would remain quite consistent with what they're experiencing now. And the remedies to housing discrimination would be out of reach for most of those people, except when there's some sort of clear indication made of if you leave that blank, then forget about it. We certainly understand that it does make things more complicated, but what we're hearing from the testimony and what our research indicates is that credit checks with name, date of birth, past addresses, all things which would be permitted would still result in credit checks. They may be somewhat less accurate to a certain degree, but this is something that still happens.
Great. Thank you. Any other questions? Will, thanks for coming.
Thank you, Mr. Chair. Thank you.
Jessica.
Response.
And members of the committee past our 3:30 time, is it okay if we wind up with this testimony?
Okay. Do you need to make it good?
We can take a 5-minute break. Would people like that?
I need to go.
Okay. But we're not going to lose a quorum, so go ahead. I'll tell you what. Jess, what's your estimate of how long your testimony is?
5 minutes, 8 minutes at most.
Well, why don't we continue then? It's all right. Go ahead, please.
Well, thank you so much, Chairman Holly. Thank you to the rest of the committee. My name is Jess Hyman. I'm with CVOEO's statewide housing advocacy programs. And you heard from my colleague Kalia earlier today about CVOEO and our work, so I won't go into that overview. So our housing advocacy programs work with thousands of people all around the state each year. Our Vermont Tenants Helpline, as Kalia mentioned, receives calls and emails from more than 3,000 renters with questions. Over the past few years, we've been seeing a drastic increase in habitability issues, rent increases, evictions, denial of housing. And many of the renters who contact us are in protected classes. And we often hear from people who are afraid of filing complaints, whether that be to their local code enforcement office, to the Division of Fire Safety, or to the Human Rights Commission, or HUD because of fair housing issues. People are concerned about retaliation and are losing their homes, and there's a general lack of faith in the system. And the reason that I'm mentioning this now in our support for H-169 is that people who are undocumented or who have mixed status or asylum seekers are especially wary of making these complaints, of upholding the basic rights that all renters have here in Vermont. And as a result, folks are living in unsafe and unhealthy living situations and facing discrimination. So we absolutely feel that adding citizenship and immigration status to both fair housing and public accommodation protections will give people obviously those additional protections, but also giving a sense of safety and confidence in the system, and that confidence to speak up, which is what makes our laws work, our justice system work. And we also feel that providing the alternatives to social security numbers in the housing search would also expand housing opportunity. And of course.
Elizabeth, 9 a.m. tomorrow. That's when we start. Go ahead, please.
Thank you. Thanks. Would expand opportunity and access. We heard earlier from Nacho was talking about losing access to housing. And in the app, I'm sorry, I lost track of where I was going here. So providing alternatives to the social security number is something that's very possible. You've heard from many folks testifying that there are ways to assess credit history, background checks without that social security number. And I would also want to add too, that one of the things that just came up that Will mentioned, talking about the difference between making it optional and making it not allowed to ask for it. There's a big difference there. There's an issue related to disparate impact. So people can make an assumption about someone's immigration status because they didn't fill out that optional line. And although they may not intentionally be discriminating based on immigration status, the impact is discrimination. So I think that's something that should really be considered under fair housing law. So especially in this tight housing market, we have to make sure that everyone, and especially the most vulnerable in our community, are protected. And the implications, of course, go far beyond housing. It's an economic issue. Limiting housing choice and limiting the places where people can live limits where people can work, as we heard. And that also limits where their kids can go to school, their access to healthcare. There's this ripple effect. It isn't just about that home, but it's everything connected with that home. So we have the opportunity here to add some state level protections to make a higher standard here in Vermont than we see at the national level. This is the right time to be adding those protections. Your first guest spoke about the credit risk analyses based on, talked about based on the current federal landscape, and it may not be wise to make a loan to someone who may be deported. And he expressed concerns about federal policy and federal policy change. But I would invite us all to think beyond that current federal landscape and create policy that's based on the values that we have in Vermont. And we have the opportunity to add additional protections and provide more safety and security for everyone who lives here. So I think other things that I would have mentioned have already been mentioned really well already today. But I would really urge you to support H169 as written with the CHT amendment as well. And I would also want to add that as we add more protections under fair housing law in Vermont, we need to look past the protections and also at the enforcement and look at how the enforcement can happen. And so to do that, we need to beef up the capacity of the Human Rights Commission, of Vermont Legal Aid, of education and outreach programs such as we have at CVOEO to make sure that we can actually enforce these really important laws and protections. I'm happy to answer any questions or elaborate on anything there. I ran through it a little quickly.
Questions? Jess, thank you so much for sitting through this and for sharing your thoughts with us.
Thank you very much for inviting us today. And I want to especially thank all the work that's gone into this bill, both Representative Dodge for introducing it, and then the work of Migrant Justice and other partners, including Kalia Livingston and Lindsay Reed from CVOEO, who have been working on this as well. So thank you for your time.
Thank you. For all the other witnesses, gracias por su asistencia.
Can I speak? Can I talk?
We did. Who are you? And tell us.
Chief Planning.
landlord. You know, I think that we're done for today. I have a meeting that's about to happen. We're 20 minutes past. If you would like to testify, you should talk to our administrator, our committee assistant. Explain who you are, what you want to talk about, and then we can see if we can find you a slot to do it. But today we're done. Thank you. So everyone, we're done for today. I haven't said the A word yet, but we are done for today. Tomorrow, we have, we're gonna have Human Rights Commission discussion. And we're gonna have the South End Innovation District housing proposal. Do we have a time for the woman who was going to testify today?
Yes.
11:30. So we're gonna start tomorrow at 9 o'clock. Any last items? We are